All right, if I could ask people to have a seat, we are going to get started with what will be a really all-star cast this afternoon. And the people who have come here from across entrepreneurial, legal, technology communities, and academic and practice is a great collaboration. We will reward those who get through the whole day with a reception that will come at the end of the day. And we will encourage all of you who are not students to spend some time visiting with our students, kind of the Silicon Flatirons charge. And when we ask questions today, we'll generally start with the students in the audience, not being afraid to call on people. And the array of supporters behind what we're doing at Silicon Flatirons continues to be humbling. They are listed, and we thank them all. We also have a special thank you. We have Pam Samuelson here today, who is really the benefactor behind our Samuelson-Gluskow Technology Law and Policy Clinic. There's Blake Reed, the new director. For those who are interested in technology policy and looking to get involved with students doing projects, we've had some great collaborations between the community and the clinic. Blake is your man. Blake is also the person who works with summer internships in DC, both in the public and private sectors. So those of you who are government agencies, companies, consulting firms, what have you, who might be open to and interested in working with us and placing students, please do see Blake later. And we'll also have here at different points Brad Bernthal, who's the head of our Entrepreneur Initiative, Jason Mendelson on the first panel is chair of the board of that, and Paul Ohm, who's the chair of our and director of our Intellectual Property Information Technology set of programs. There's a whole bunch of programs coming up. In an interesting experiment and an encouragement to all of you to suggest experiments, we're holding one at the Medical Center. That's next week. In full disclosure, that was motivated in part because my wife works there. She's in the med school faculty, and she says, Phil, if you're doing a program on healthcare innovation, you have to have it at the medical school. And so we are doing it. And Anna, we have over 200 people RSVP'd so far. I need to give another shout out there. I don't know if he's here yet, Dave St. John Larkin, whose wife is also at the medical center, kind of underscored my wife's suggestion, and it's working out really well. So any ideas you have, we had a program downtown last year with Judge Kaczynski on trademarks and non-traditional IP rights. Please bring your ideas to myself, to Paul Ohm, Brad Bernthal, to Blake, to others. We love all your ideas and love working with you. So without further ado, let's have our first panel come join me to get things started. I've already introduced Pam Samuelson, who's a distinguished professor and MacArthur Genius Award, and is just an amazing person. She's been a great friend. Suzanne Michel was at Google, had previously been at the Federal Trade Commission. Jason Mendelson, a venture capitalist here at the Founder Group and for the lawyer. Michael Kallus coming to us back again from RPX. And finally, Pat Kennedy, a local entrepreneur. Great to have all of you on this panel. Dave St. John Larkin just came in. I gave you a shout out at the Healthcare Innovation Conference next week. We got over 200 people registered already. And for those interested in IP and healthcare, there'll be a lot of entrepreneurs talking innovation. Please join us next Wednesday as well. So this panel is meant to set the table about what are software patents, how do they impact on innovation. As I have said, in regards to her personal connection, we're lucky to have Pam here today, but actually she is the author of some of the most important research on this question about what do software patents do for entrepreneurs in terms of spurring innovation. And if I could just ask you to start off, Pam, discuss your research briefly and what are the implications of that research, that would be really helpful.
So I have been studying software intellectual property for more than 30 years, and so this is a subject that I follow quite closely, but part of what interested me in the early 2000s was a question about, now that we have a much more mature software industry than we had in 1980s when I first began studying this, I was interested to see what role intellectual property plays in the ideas of the entrepreneurs about how they can attain competitive advantage and the like. So in 2007, we designed a survey. We sent out survey forms to, I think it was 13,000 people. We ended up with 1,331 responses, which is not fabulous, but we were able to compare some characteristics of the non-respondents and the respondents, and we have reason to believe that actually our respondents are typical of the people that we did get responses from. More than 700 of them were people in the software industry, and part of what we saw there was actually, if you ask the software entrepreneurs, what is it that is going to help you attain competitive advantage? First mover advantage is number one by a lot. Complementary assets is number two. Copyright, trademark, and secrecy are together as important phenomenon. Difficulty of reverse engineering is down there too, but the least important of the ways to attain competitive advantage among these software entrepreneurs was actually patents, and it was dead last, and it was really unimportant by comparison with the other features. So we thought that was really interesting. Another way to sort of understand that was that of the Dun & Bradstreet respondents, 3/4 of the software entrepreneurs did not have patents and were not seeking patents. Among venture-backed companies, the percentage of firms that were seeking patents was higher. But even so, there was still about 1/3 of the software entrepreneurs who were not seeking and had no patents. So there's some interesting things going on there. A story that some people want to tell about patents are really important for promoting innovation in the software industry doesn't really seem to be borne out by the data that we collected. The report about the 2008 Berkeley Patent Survey is available on the internet, and so I encourage you to take a look at it. But those are at least a few of the crisp findings that we had from that survey.
So, Pat, I want to go to you as an entrepreneur who has received a number of patents, although I'm not sure how many of them were software patents per se. What's your thought in terms of how you built your business over time and how patents played a role?
So we built 4 portfolios over a 20-year period in an area focused on universal wireless connectivity, sort of in particular in the vehicle space because it was a frontier area. And we don't have any pure software patents. They're all utility. Internet connectivity, protocol conversion, all manifesting itself in both hardware and software. But we had an open licensing policy from the beginning, so we weren't exclusionary with our IP. And I've actually never had a lawyer suggest a software patent or a design patent in our business. So we only file utility patents. And over the 20 years, we sort of filed maybe 1 patent a year. So we really tried to only put our IP resources on meaningful IP or property.
And in your case, you would say that built part of the company's value proposition is actually having this intellectual property portfolio.
I would say it's the vast majority of our value today.
Jason, Pam had a damning statement in her research for VCs, at least VCs like yourself, who would say that software patents maybe aren't as important as some suggest. Being venture-backed is more likely to have you get patents than not. Do venture capitalists tend to push or value a patent portfolio?
I think unthoughtful venture capitalists push having a patent portfolio. I think that, but that being said, I think we're pretty thoughtful about the issue, and all of our companies get software patents because we need a shield against the trolling effects that are so prevalent these days. So, the way we tell them is it's a necessary evil, it's a business expense / tax, but you're probably better off having something so you at least have a shield in case you get whacked one day. And this isn't about legitimate patent or IP theft. When there have been cases in our portfolio, and I was on the board of the NVCA for 4 years and just rolled off, and the way we looked at it as a board, there was a very bright line. There was the non-software stuff and then the software stuff, and I think most of the VCs who are thoughtful about the issue said, you get them for the trolls. If you find out you have a company that is infringing on the IP, do the right thing. Like, we're not in to be a lawless society here.
So, Suzanne, I've seen it reported that Apple and Google each spend more money on their patent costs than they spend on research and development. Is that true? And if so, what do we make of that statement?
I think it was most likely to be true in 2011. and hopefully will not be true in the future. 2011 was a bad year for everybody, right? And in 2011, Apple, with some other companies, bought the Nortel portfolio for $4 billion. Google bought Motorola for $12 billion. $8 billion of that, approximately, people, or the analysts, not Google, have associated with the patent value. So in that year, definitely, both companies spent way more acquiring patents than they did on R&D. And the public reports of Google's R&D are on the order of $5 billion a year. I would say ongoing right now, our yearly expenses are not that high, but it's an interesting point of reference in what it says about how the tech industry deals with patents and the need to build up these massive portfolios in order to have mutually assured destruction, and that it's not about having patents to protect your own innovation, the classic patent story, but it's really about having patents to cover your competitors and also to have a really big stack. And the amount of money that the tech industry, and it's not just software, but it's tech overall, spends on this kind of defensive patenting is contrary to the classical patent story, and one might argue fairly wasteful, and the money could be better spent.
So, Michael, I suspect given RPX's role in helping facilitate patents being monetized and licensed, you may have a more charitable view of how patents operate. Is it a tax, or is there an opportunity for the inventions to be monetized and thereby go back to incentivize further innovation?
It's an interesting question. It's one I sort of think of a lot, what sort of benefits are patents providing companies, including software companies. And I think intellectually it's a difficult concept because it's usually the monetization of a patent is so far divorced from, in time, from the moment that the innovation was made. So by the time you see a company filing a litigation, oftentimes the response is, everybody does this. But aren't we just sort of redistributing the value of the initial innovation to a point later in time? There's some bad patents out there. There's some bad patents that are making some pretty good money. RPX's stand is we're very neutral, on patents, either good or bad, but the notion is, one evaluation. So I don't know how much that answers your question, but.
Well, it sounds like a dodge, which is okay. That's okay. The comeback will be to talk a little bit about what Jason has adverted to. He used the word patent trolls. I'll be a little more polite. I'll use the word non-practicing entities. If Suzanne wants to call them patent assertion entities, which is the Federal Trade Commission's preferred term, or someone else, that's okay. We're talking about entities that hold onto patent portfolios but have never been in the business of actually producing or selling products, and use those portfolios in strategic ways, which often means actually conducting or threatening litigation. In software, I've seen these numbers. Is it as high as 60% of all NPE litigation activities in the software sector? That's, to me, says something interesting, because not 60% of all patents are in the software sector, but 60% of all NPE patent activity is. An interesting question is, okay, what's going on there? One hypothesis by Mark Lemley, who has written on this, is that there's a lot of, call it, functional claiming in patent software patents, where people claim this broad function that may not have been invented yet or even used yet, and so it's out there, and then later someone gets a hold of one of these patents, and when someone's actually doing it, can threaten or bring a lawsuit. And some would say that's more likely and happens more often in software than other sectors. I don't know if that's the best explanation, but it's certainly an interesting question. Michael, you kind of said it. What are some of your thoughts on that?
That's something I can't respond to. I mean, that's more in my wheelhouse. Do want to make one response to a comment I made earlier, which is sometimes I hear startup companies saying that they do need to acquire patents in order to defend themselves from patent trolls. Of course, the effectiveness of an NPE, a PAE, or a patent troll is predicated on the fact that you can't countersue them. So when I see startups picking up patents, it's generally to protect themselves against competitors later. But moving from that, so are software patents more amenable, more interesting to patent trolls than other types of patents? They absolutely are. And they are for certain reasons. There are a lot of them following both, the .com era. There was a huge spike in both application and issuance, and that has continued to the present day. So they're out there. They're highly liquid. There are a lot of startups that are constantly either dissolving or being acquired, and those portfolios are getting spun out. So there's not only a high supply, but a high degree of liquidity. That means that they can be purchased. Software patents are, I think anybody who's taken a look at them, oftentimes usually vague, which gives itself to being a useful litigation tool for an NPE. It more or less necessitates it that you have to go through claim construction, which is a very expensive point of litigation for a small company to reach. And then you throw in the massive spike, I think also, you have a lot of companies using these software patents. I mean, you look at the retailers, not somebody you traditionally think of as a tech company, but they are just getting absolutely run over by NPEs. Why? Because their online portal is, after all, software.
Just a data point on this, Crocs, a local company, their general counsel said their #1 legal issue, I thought he was going to say like their product being counterfeited, right? He said getting sued for e-commerce by, he would say, patent trolls.
Yep, and I speak to the retailers all the time. They're more in shock. At this point, they're starting to respond to the NPEs, but it's an absolute surprise, in the words of a noted women's intimate retailer, we make bras and panties. We're not a technology company. So it's very understandable, but those retail companies are great targets for NPEs. Why? There's technology bottlenecks. You need to offer certain services for people, a secure transaction portal, an inventory of your database, the ability to search things. As a result, there are plenty of places that they can all get sued. You've got the perceived deep pockets, and the ease of detection, which was referred to earlier, is easier. I mean, you want people to find your website. So you put all those together, and what you've seen, and this is where we're going to give a little bit in terms of number, is a huge explosion in the number of software patents. From 2007 through 2009, it was actually fairly static. About 100 litigations a year, and about 350 unique companies were getting sued. Of course, that would be Apple, that would be Google, that would be Microsoft, the sort of companies that you would expect. 2010, the number of litigations increased slightly to 165, but the number of unique companies getting sued jumped 314% to over 1,000, and that's about where it is today. And that's why we're seeing, with the numbers and whether 60% is the right number or not, all of a sudden you're seeing the entire verticals getting sued. The people who make the software, the people who sell it, and the people who use it.
Pam?
So I think that there are a number of reasons why software has been the focus of so much NPE activity. One is because under the standards set by the Federal Circuit from 1998 to relatively recently, the patent subject matter was not being looked at all, and so something like performing a particular function on a computer or performing a function on the internet were patents that were not being struck down. That's the kind of functional claiming that Mark's talking about. And I think under the Supreme Court's more recent opinions, something that's a functional claim is too abstract, in fact, to be patentable. The problem is that there are these many thousands of patents that were issued during that time period, and the Federal Circuit still wants to act like those are presumptively valid and it takes clear and convincing evidence to overturn them. And the Federal Circuit in much of that time period also wasn't being as rigorous about non-obviousness as the Supreme Court said that it should. And in addition, they're not trying to get as much disclosure and written description of what the invention is. And so by not being rigorous on those things, it's encouraged a lot of the patent lawyers to write claims that are very broad, very vague, very abstract, and the patent examiners, are in a situation where they have to prove that something's unpatentable in order to not issue the patent. And so many of the patents were issued that shouldn't have been, and Besson and Moyer basically point in their book called Patent Failure to the lack of disclosure and the abstractness of software patents as attracting a lot of this activity. I think that some of this NPE activity wasn't quite as worrisome maybe 5 years ago as it is today, because 5 or some years ago, that was mostly being aimed at big companies. But big companies like Google and Microsoft and so forth, well, are willing to fight some of those NPEs and to attack some of those patents. Now a lot of the assertions are coming against small companies, and that's having real significant operational impacts on those companies, as Colleen Chen's recent study on startups and patent trolls suggests.
So that was a great segue, Pam. I was going to actually go back 5 years on a panel here. I believe Paul Loam was moderating it with, I believe, Jeff Manny, formerly of Microsoft, where Jeff suggested to Jason that these patent trolls wouldn't really be suing startups, because that wouldn't make any sense. Well, now we know, documented, as Pam said, they are getting sued, and you said at the time they were too, but Jeff was skeptical. How do you explain that? Because it is a situation where it would seem like they don't have a lot of money. They wouldn't be the target that Google would be, but yet this has become a real issue for them.
I think many of the trolls, I refuse to call them NPEs, have a similar business model. You start small with a lawyer, with a patent, and you go after people who are willing to pay you something and to settle, and then you use that to go after other people. If you go after Microsoft or Google, you're in a jihad with these guys. If you go after a whole bunch of startups and you say, give me $50,000, the question, what do you do if you're a startup? Yes, you don't have $50,000, but you don't have $500,000 to litigate it. So you hand over the 50, you settle, and now you set precedent where they start going around to your competitors. We've seen these entities actually go after the customers of our companies and try to work backwards up to the companies and go wide range. It's a disease. It's cancer, and that it's going to attack whatever cell it can get its hands on first and use that to try to broaden its scope.
So, Pat, you have an interesting situation here because you started out producing products and you moved to a licensing model. Thus, the NPE category is one that someone who doesn't know your history could label you.
Right.
How do you think about this category? And for policymakers, we'll get to this in the subsequent panels, this will become important. If you want to go after the strategic actors who weren't a part of any invention, you have to ask the question, how do you do that without going after, let's say, a Pat Kennedy or a Berkeley, who also could be vulnerable depending on the regime?
Right. Well, I sort of agree with Jason. A lot of these trolls are shakedown artists. They target industries. They're trying to extract anywhere from, believe it or not, $50,000 to $250,000, so you'll go away. And it's a problem. But for a company like mine, I see it as a bit of a benefit because it differentiates us as real inventors who put real product in real vehicles, and we have a history of licensing from Motorola and Continental. So we're not begging for justification. And when we litigate, I think people take us more seriously. But it's a very big problem in this country. I empathize with the entrepreneurs. I agree with Michael's point that if you're a startup and you're getting patents to fend off the trolls, it's a why bother? Because the trolls aren't armed with patents.
Let me just answer that. You bother because you're hoping to get prior art. Just if you're a startup, you're going to try to patent a day because tomorrow may be the troll. The things we're seeing now is you have so many startups doing the same things.
Right.
And you have these liquidation firms now that are winding these things up and then selling the patents to folks.
Okay.
And now you at least have a shield against that. I agree, and whether the trolls can be sued now, that could be a whole other boring debate that we don't want to have. But remember, it's you got to look at future and past, not just the past.
You've got to put a stake in the ground.
You got to put a stake in the ground because you never know who's going to come later. I mean, for instance, Google wasn't the first search engine, right? Who knows what could have happened? They had to lay a stake in the ground then. There was a past and there's a future.
Right.
Pam?
So I thought I'd tell you just a brief story about my opportunity to become a patent troll, which I turned down.
Which is why we like you.
So my husband started a company some years ago in the late 90s, and they got a patent on using documents to exchange for e-commerce. It basically covered web services. They got the patent to have freedom to operate. The company went public, had a good success, and then didn't make it over the next decade. But the guys who wrote the patents got in touch with my husband when the company was in bankruptcy and wanted us to invest $250,000 to buy the patents because the patents had been separated from the other assets in the company. And since everybody was doing web services, this was going to be a very lucrative opportunity. And so my husband and I talked it over and declined. And then we got in touch with everybody that we knew at Microsoft and every other big software company that we could and said, these patents are about to go on the market. You know, if they could buy them in secret, right? If we had actually wanted to participate in that, they would have been able to get that. And then eventually they were bought at auction for $14.5 million. Novell ended up putting them in an Open Innovation Network pool, so they didn't end up doing bad damage. But it's exactly this kind of, you know, small, let's try to get these things that are in bankruptcy that I think have created some part of the problem.
So there's two heartbreaking stories. One was told to me by Brett Feld, who's here, about not one, but two entrepreneurs whose patents that they came up with at one startup company was later used, bought by a non-practicing entity, and used against them in a lawsuit. Right? Was that twice? The other painful story, though, I want to ask Suzanne about this, is that lots of large companies sitting on patent portfolios are having their board of directors saying, wait a minute, these patent portfolios are worth money if you monetize them by licensing them to non-practicing entities. And not all companies are able to have, let's say, the moral high ground that Pam was on, because they're feeling the pressures of whatever financial or shareholder pressures. How big a dynamic, other than the bankruptcy problem where I talked about, is the large company patent portfolios that are actually practicing in some areas, licensing through others in an often non-transparent way for them to get some monetization, but to fuel this cancer, to use the metaphor?
Yeah. So I don't know that we have the numbers yet to say exactly the size of that problem, but it is a big problem, and in a lot of ways the most frightening problem, right? It's clearly going to continue and become worse and worse. You've heard a lot that the troll problem has grown. There's 4 times as many defendants being sued now as there was in 2005, a lot of them being, half of them being non-tech, a lot of them being small. The problem is huge, but it continues to be, you know, we've got, I'd say Google and Motorola have close to 70 suits together. We had 2 in 2005. It's also a growing problem for big operating companies. Those patents come from a lot of different places. They come from the defunct startups, but they also come from operating companies who sometimes they're just having money trouble or they're having cash flow trouble. And the CEO goes to the patent lawyers and like, why are we sitting on all these patents? Let's sell them, let's license them, whatever. So they sell them off. And it disrupts what I talked about earlier, that defensive patenting regime that the tech industry had operated in for such a long time of mutually assured destruction, where I have my big stack of patents and you have your big stack of patents and we're not going to sue each other. Well, someone finally figured out, you know what, I could just sell those patents to some troll, get my cash that way, and the troll can't be countersued. And it's actually a sort of evil genius kind of problem, and we're seeing it more and more, and it's I'm really not sure what to do about it. You see the antitrust agencies getting interested in this to the extent they're calling it privateering. You know, are these patents being sold for some kind of competitive advantage in the marketplace to target the original owner's competitors in some way? Does that raise the antitrust implications? That's one way to look at it. But I think ultimately something we've all got to wrestle with in terms of the whole bigger troll problem is to really understand the root causes of what's happening and to try to address it at the root cause level. In doing that, I think when you get to the root causes, you also, the question you asked Pat about how do you distinguish between you know, people who are really creating some new technology and licensing it out, and those who are buying up junk patents and just asserting them broadly. When you address root causes, I think you don't harm the business model. That's a licensing business model based on good technology in the same way. So I hope that's another conversation I think we can have about sort of what are those root causes and how do you deal with them.
I think the problem with that, I agree that it's a good thing to do, but the problem, of course, is all the legacy patents that were issued under the kind of not ideal circumstances. So I applaud the effort to attack the root causes, but we need some strategies also for dealing with the legacy of the things that shouldn't have issued in the first place.
You always hear about the USPTOs suddenly going to have a magic wand passed over, get full funding, and issue great software patents, but I'm sure you've seen pretty much every idea in telecom from a general standpoint has been done, and there's people going around doing bad things with it.
Oh yeah, oh yeah. Well, one of the issues with software patents is talk about gaming the system. Because they're abstract, they're relatively easy to get by judges when it comes to a very critical part of the patent litigation, which is the claims hearing, which has a specific name.
Claim construction.
Markman construction. So if you get past the judge on the Markman construction, the other side's bill goes through the roof. Is that fair? I mean, isn't that where most of the brain damage takes place? So the judges allow these Markman constructions to happen, and then maybe you get it by a jury or not, but then you have to go to appeal. And this is where I think the market will have correction, because it appears that at the federal appeal level, the judges are looking more cynically at patents and litigation. And what we now hear amongst those in the patent business, and I write pretty extensively for a patent journal and go to a lot of conferences, is it used to be infringement, now it's validity. Do you have a patent that can really stand up on appeal? And that's the way it should be, frankly. But I think there's a corrective action. There's a lot of patent trolls who are, frankly, I don't know one of them that's not a lawyer. And they're chasing the money very smartly. But the system, I think, will correct itself. The question is, how much time and how much damage?
I'm a little more pessimistic about how much some of these problems get addressed, because in particular the claim construction, which I think you are absolutely right. That's a significant issue that's not discussed enough in the problems with the Federal Circuit's approach to claim construction, in the way that it feeds this problem. And that is, we've all talked a lot about the vague software claims, and these are the ones like that. I'm thinking of a patent that was about renting software and downloading it to your computer, and the claims had phrases like a selector for allowing the customer to select a product to download. And like, what do all these words mean? And we don't know. And that's a lot of problems about how the patent office deals with the patent, how much they push on forcing applicants to define their terms, how much the Federal Circuit case law forces applicants to define their terms. Not enough, it should force them more. But then all of that is compounded on top of this concept in the Federal Circuit that claims should be given their ordinary meaning, and that we don't really have to worry about what was actually invented, right? That you just take the claims in some sort of isolationist box, and these claims have words that are meaningless in them, pulled out of nowhere with no standard terminology, and they end up having this sort of broad coverage, which makes them extremely valuable to a patent troll who wants to sue every single person in the world with a website. And so I think both the patent lawyers call the 112 issues really reining in and making the claim scope, making it more tied to the specification, less vague, but there's also an important place for claim construction. And I am skeptical that the Federal Circuit's going to get this and fix it. And so we've got a ways before we get that case to the Supreme Court.
So we're going to come back to the judicial avenues, but I do want to stick with a data set that's worth talking about here that's outside the startup situation, which is the smartphone wars.
I don't like that.
If we wanted to give you the scorecard, I know, Suzanne, like, do we have to?
Really?
The chart of how many lawsuits have happened among these different companies in several different forums is dizzying. That said, this is an area where operating companies are suing one another, and where Apple's theory of the case would be, we actually invented some of the technology here, we should be able to keep it proprietary and enforce our property rights. So to start from the skeptical point, if you're skeptical of software patents, how do you respond to that claim by Apple?
Well, I think that there are more than one kind of proprietary right, and I think that other proprietary rights work better for software than patents do. And so we have a situation in which I think, as we were saying before, the story that people were telling at the time that they were building up these portfolios was, oh, we're just going to do this for defensive purposes, freedom to operate, we'll license them on open terms and the like. And then you have a competitive situation, which is a big temptation to use it for the other purpose. And I think that that's what we've been seeing. And the markets are so big that I can understand the temptation to take something that you thought you were doing for one purpose and using it for another purpose.
So that's it. I had not heard, so Apple originally, when they patented their smartphone technology, had said, we're only doing this for defensive purposes, and later decided otherwise. Is that, Suzanne, you're looking quizzical. Was that their narrative, or did Apple never say that?
I don't know their narrative on that particular point.
Jason, as an observer, what's your sense of Apple's perspective?
I don't know. I'd stay away from the big company stuff. They all scare me.
So, Pat, you've watched this space. Care to comment on it?
All right, so yesterday I called a friend of mine who has recently retired from Motorola, and he was the lead design of this product in 2002.
Whoa,
And I asked him, his name is Mike Bordelon.
Is that still your phone?
that's like retro.
No, actually, I gave it a few days ago. It fits nice. So this
You can put it in
phone,
the
I asked this
museum.
fellow, his name is Mike Bordelon, how many patents that he felt that phone probably used or infringed on, and he said maybe 1,000. And I said, did you, when you incorporated some other people's patents, did you ask for permission? He said, of course not. Okay. So he admitted that I just designed on, which is the way people design products. This has 10 to 20,000 patents. Fair enough? Right?
Over 100. RPX's estimates are 250,000.
Yeah, but they're in the business of selling protection.
Yeah, but so let's, a lot.
Okay, so the way I look at patents, so this has 2 wireless links in it, analog and digital, and this has 5 wireless links in it, right? This has an antenna, this doesn't. So the people who invented the antenna technology should be compensated. Fair enough? Okay. This has no accelerometer. This uses an accelerometer quite cleverly. The accelerometer company should get paid. The question is, where do you draw the line? And if it's a software patent, it's kind of vague. Good luck trying to take Apple on. But if you've got an accelerometer patent, you should take them to the bank.
I'll say, I think one of the difficulties that we're struggling with in the smartphone wars, because they've been, let's say, inconclusive to date, I think that's fair, is Pat's point about how many patents are in these products, whether it's 250,000 or 50,000. It's too many to make sense of and keep track of. I mean, at some point, it just doesn't matter what the number is anymore. We're clearly there. But the other problem is an evaluation problem. We litigate patents one at a time because that's how, maybe 5 at a time in a district court case. And we don't have good economic theories for figuring out what the value is for one patent in a product covered by 50,000 patents. We just don't. And it overinflates the value of the patent being litigated. And I think drives litigation in a way that's not productive. It also that's what drives a lot of troll litigation, is that these patents become sort of inflated in the context of one lawsuit. And I'm really hoping for some really brilliant economists like Carl Shapiro to figure this all out for us. And
So to say what Carl might say on this is, if you had even, let's say, 20,000 patents, and every patent holder got to say, I want to have royalties of even 0.5%, do the math, it doesn't work.
Royalty stacking.
Right. So that's the Carl's phrase, royalty stacking, and it's not necessarily unique to software, but it's so much more vulnerable in software.
Right.
In the pharma world, getting back to your point, it's often like on a new drug, 1, maybe 2 or 3, a handful of patents on the drug, you don't get this same dynamic you get in software. You've got, you know, tens of thousands. So you're from RPX, what's the right number?
First of all, 250,000 wasn't our number.
Okay. That was Randy's number.
Somebody said, we cited to it in a blog post or something like that, so I guess we've endorsed it. But what's the right number? I have no idea. I really.
But it's huge.
Obviously.
And how do you value this, you know, agglomeration of patents, some of which may not actually be valid?
See, that's the difficult thing, and that's where RPX, you know, we try to sit in there as the middleman. Clearly, the MPs are taking advantage of like gross inefficiencies, because to a given jury, and if you're only looking at one patent, you say, wow, this is really contributed to the end of it. And without taking into account the royalty stacking, it's incredibly hard to get a relative idea of the contribution. We're not in that business. Obviously, we're in the business of these one-offs. I mean, the gross number, the gross majority of patents never get to litigation. They really don't. They don't get this far, so we focus on the ones that are big threats and threats to our clients. And so in that, we get involved in the valuation stage at that point. But part of it has to do with this inefficiency. There is this myth that patent trolling is just wildly profitable. It is very profitable, but in fact, like there are huge inefficiencies for NPEs. As a result, somebody selling a patent is willing to do so usually for 1/10 the amount that they're going to make if they run a campaign later on. It could be invalidated, all sorts of things. Somewhere in there is an attempted valuation.
So we're going to get later in the day judicial solutions, administrative and legislative solutions. Two solutions I want to talk about now. Some, including I think Brad Feld, have analyzed software patents to derivatives and what Buffett called mass instruments of financial destruction. In the derivatives, we did have insurance, right? Remember AIG. First question, is there insurance going on now, either for emerging growth companies or other ones, to actually try to offload some of the costs related to MPE litigation, other overhead? Jason?
Yeah, it's prohibitively expensive, though. I mean, it's 6 figures plus. It's a, you know, small startup. Would you rather have an engineer, or would you rather have insurance that you may or may not use? And it's very vague in how it works. It's hard. There's a whole bunch. The devil's in the detail. The insurance products are not sophisticated enough to actually, in my opinion, to really handle the situations. And by the way, I mean, you know, bringing this back to innovation, which is what we're talking about. I mean, the real, you know, these costs, whether you pay an insurer and it works, or you're making a decision to take a head out of the innovation engine, which is an engineer usually, in favor of a financial product. So by definition, even if they do work, it's still not good for what the patent system was set up to do, which is to spur innovation.
Michael?
Yeah, well, so we're in the business of selling patent insurance, so I'm not going to put in a big plug. I will agree on the point that you're right. I mean, you're doing nothing more than transferring the risk. It doesn't get to the core problem. Somebody's paying, you're spreading around a number of companies. That is the purpose of insurance. I think we're talking about getting rid of the overall cost. But in addition to doing business development acquisitions, RPX, I'm also a licensed insurance salesman. So, you know, there are policies, there are different approaches to it. I think it's doable. It doesn't get to the core problem, so I'll leave it at that.
So one solution to the core problem that some have mentioned, and Pam's already referred to this, is if you just ended software patents entirely, let people work on copyright, trade secrets, trademark, you know, et cetera, you might live in a better world. Let's talk for a minute about that alternative world. I think the other panels will probably talk more about fixing the current regime. Pam, I'll let you start off, and please grapple with two of the obvious objections. One is all these patents that have been granted, can you just literally wipe them all away, like barnacles off the ship? And number two, as Pat adverted to, sometimes software and hardware kind of functions in a sometimes interchangeable, interdependent way. How would you disentangle those as a matter of administering the patent system?
So I think that this is the hardest of the problems from my standpoint. One thing that people can't quite agree on is what is a software patent. So there's the problem that if you wanted to wipe them all out, how do you know which ones? So I think that actually may be something that some guidelines can be developed about. I think that with the Supreme Court having two cases, the Wild Tangent case and the CLS Bank case, petition for certiorari pending, I think they're going to take one or both of those cases, and I'm hoping that will actually give us some guidance that we didn't get before. But I wrote a paper, and I actually brought some reprints, so I hope somebody will take my reprints, trying to look at what has the Supreme Court said is too abstract to be patented. And if you kind of take the criteria and try to take them seriously, then I think you can actually have some guidelines for functional claiming, for example, is something that should be struck down as an abstract idea. Things like the Benson algorithm for transforming binary coded decimals to pure binary form. That mathematical algorithm is something that the Supreme Court by 9-zip back in 1972 and by 9-zip relatively recently has said that's an abstract idea. And I think if you kind of make an effort to kind of look for the clues of patentability and the clues of unpatentability, I think we get there. I think just naming a general purpose computer or the internet in the claim is not going to be enough. But I think that to the extent that you're claiming a process that has an interaction and a special purpose computing device that causes some effect that happens in the world, that seems to me to be something that you could develop guidelines to say, well, these are the things that are on this side of the ledger, these are the things that are on that side of the ledger, and then pattern match, see which claims that are before the court kind of fall on this side of the ledger or that. And so I'm hoping that to submit another amicus brief to the Supreme Court in the CLS Bank case, and we'll see what happens. But you see the Federal Circuit, 10 judges heard this case en banc and issued 7 opinions, and was fractured all over the place. And so they're clearly not going to solve the problem.
So, Suzanne, sticking with the Supreme Court, trying to solve it categorically, the court could not do that for business method patents in the Bilski case. So I don't know that I can take the side of the bet that they would go further than that in some other case. What do you make of Bilski and the Supreme Court's appetite for really narrowing down on a categorical basis what is patentable subject matter here?
I think the Supreme Court's clearly got to take one of these 2 cases. I don't know how they avoid it, given that the Federal Circuit split 5-5 and openly admitted that it was unable to deal with the problem. So whether the Supreme Court wanted to do this or not, there's no choice. So it's going. And there's clearly another case to be decided, and I'll tell the story of Pam. This was like years ago. Actually, I think it was, you were still at DOJ. But Pam and I were having a discussion at the time that Bilski was being argued, and Pam said, this is just the first case. This is the easy case. This is mental steps. Of course, this one goes. The Supreme Court still needs to take a medical diagnostics 101 case, a gene patenting case, and then the software case. And lo and behold, here she's completely right. And they now need to take software case. So I think the easy case is CLS Bank, if that one goes. And that what all that is a computer program to do the Bilski claim, right? Do some sort of financial thing. And it's going to be not that hard for the Supreme Court to say, just taking this sort of abstract financial idea, plugging it into a computer with nothing else is not good. The harder case is the wild tangent case. Will they go farther? Because my take on that case is the claims look long and complicated,
But they aren't.
but they really aren't. They're really about show a commercial and then show a video on the internet, and they're really not anything else. They're just long and complicated. So I think the Supreme Court, to get back to your question more directly, is likely, my prediction is likely, and it will be helpful to draw some lines on these kinds of, they won't outlaw business methods. They don't want to make a huge broad statement like that. I think it was just an uncomfortableness with a huge broad statement that you can't predict all the consequences of, but that they will give more guidance in these coming cases about just sticking something like Bilski into a computer doesn't cut it.
Phil, can I ask you a question?
Yeah,
Paul?
please.
We were sitting there watching the Bilski arguments. Thank
Yeah.
you for taking me. I even wore a tie for you that day. It was a big day in my life. tell me I'm wrong. We sat there and we walked away sure they were going to blow
Yes.
that thing
I
up.
mean, I think, I'll go even further. Pam may have the same view. I think Stevens lost one vote
Yeah,
he
late
did.
in the process. So I think he was actually, from conference, going there to take all business method patents off the table, which a lot of people would say, even those who defend software patents, that business method patents are that much harder to really justify, and somehow they chickened out. Who and why? Do you have a guess?
Scalia.
Why?
Justice Scalia, I think, was unwilling to give Justice Stevens his swan song. This was the last opinion that Stevens was going to write. So no, I think it's that. I think it's that petty, actually, because he.
Can we
I
just
think
go?
that's
I mean, why are we here? Let's just leave. Like, if that's what it really is.
We don't know. No, the truth, we don't know. We may know at some point in time, because like these records come out of
Some
like
memoir is going to
conference-
come
No,
out.
Right.
No, because actually, if you think of it,
Yeah. But I mean, we were there.
Yes,
Um,
I mean, it looked from the oral argument that they were going to get the votes. You can look at it and you can get a sense that maybe Scalia switch is the most likely bet,
Yeah.
and who knows
no,
why.
because he concurred with a Breyer opinion that said it concurred with everything in the Stevens opinion, but Scalia didn't join
Yes.
the Stevens opinion. He only joined
The Breyer.
concurrence. The
Yeah.
Breyer submitted. So he was the fifth vote that went the other way, which is kind of interesting because he was the first questioner at that oral argument. He asked Mr. Jakes, the guy representing Bilski, whether a method of winning friends and influencing people was patentable subject matter. And Mr. Jakes said, "Yes, Your Honor."
And the entire court went crazy, and then Stevens, if I remember right, asked, so if I learned a better way to teach tax law to students, I could patent that, and they said, yes, Your Honor.
Yes. Yeah.
That's where this thing was going.
Yeah, yeah. Well,
But-
actually, I think all the what the Solicitor General called the human activity patents, I think those are all out the window.
Yeah.
I think that all of those are out the window. So even though some of us who were hoping for some particular things out of the court's opinion didn't get everything that we wanted, those human activity patents, the tax planning methods, the jury selection methods, the arbitration methods, those are all out now.
And
And they're not-
Congress did, in the American Vents Act, specifically speak to, I think it was a tax planning one.
Yeah.
Wall Street wins again.
And so, but they're not, so those aren't being asserted anymore. I think maybe as a consequence of Bilski, those human activity patents aren't really being
Yeah.
asserted. So now it's a computer program too.
Same
Da, da,
thing,
da, da.
right.
And so now what do we do with those?
I mean, you asked about should software patents exist, and whatever, we can go back and forth, but I mean, think about if Yahoo and Excite and Alta Vista had been able to lock up all the software patents for search. Where's Google? Probably not where they are today. They didn't compete on patents, they competed on a better team, better mousetrap, better business plan, and we're all better off for it.
Well, it all gets to the level of generality, and if the function is defined as broadly as accessing a website from a phone to order something.
There's a patent for sending confidential information over the internet.
Right. As opposed to inventing encryption technology that actually is unique.
Correct.
And that's, and the hard question about the categorical approach is you sweep out some legitimate inventions, but you prevent some of the shenanigans too.
So that's really an important point, that this isn't about, and I don't know that anyone's even suggesting abolishing all software patents.
Now, some are suggesting that.
Some are. Google's
Good luck.
not. So we're in a place of line drawing, and line drawing is always hard, but I think there clearly are those sort of a computer program to do Bilski that shouldn't be, and the encryption patents that clearly should be, and now we're just struggling with drawing the line, and what's important.
So let's get some of our audience involved. We've got a lot of great people here today, starting off with some students. Yes. Brandon's got the microphone. Brandon does not mean to volunteer to ask the first question.
Whoever does have a question.
Since you've been talking,
Yeah.
since you've been talking about software patents for an hour, and the professor made some mention of concerns about the definition, Anyone like to take a stab at defining that term?
Pat, since you said you were not doing pure software patents, how do you define a pure software patent?
I wouldn't know, I've never done one. I'd avoid them, personally.
Michael, you wanna
Because I
try?
think, one, you can work around them if you're clever enough, or if it's too broad, it's not going to stand up on validity, my impression, you know. As an investor, inventor, that's the way I would answer you.
Yeah, so I'll give you another sort of vague answer. I heard a software engineer friend of mine once say, there's really nothing here that I can program that I couldn't wire a circuit board to do, and so what's the difference? So I have no clue. That's my way of passing.
Suzanne, you want to try?
Well, that's a really important point about why it's so hard to talk about abolishing software patents, that anything could be done in hardware too, and it's just a design choice. And so it doesn't make sense to do that necessarily. I think some of the statistics you hear about 60% of patents being litigated are software patents. I've even seen 80%. Those are very broad definitions where if anything in the claim would involve using software, that's a software patent. I think when we talk about the problems of software patents, that's not what we mean. We really mean these kinds of claims that recite a general purpose computer or just on the internet, display means, network connections, those sorts of things. And the heart of the invention, the point of novelty, is something that the software is doing. And generally recited at a very high level of functionality at the point with how the user is interacting with the program, rather than anything at a lower level of how the program's operating.
Jim Gunderson, Gamma 2. We're on the small entrepreneurial protect our IP side of things. And I guess my question is really about the impact of first to file versus first to invent and wrapping into the whole software trade secret protection strategy. I mean, what do? You keep your stuff trade secret, somebody comes up with something and does a first to file, and now you're where?
Pam, that's an interesting, even with the patents available, entrepreneurs you talk to still prefer trade secret. Can you explain that point?
So I think it's because on average, well, there are a couple of things. Well, on average, trade secrecy is more reliable because it's so difficult and expensive to try to reverse engineer to learn anything. So that's actually, I think, difficulty of reverse engineering and trade secrecy are two of the interacting sources of proprietary rights. The other thing is that with a lot of the internal design elements of software that may in fact be inventive, even if somebody else gets a patent on that, they may not be able to tell you infringed because the design is actually embedded in the software, and you'd have to know something about how it in fact accomplished this particular objective to be able to sort of sue for infringement. So to me, the sort of the software patents that are actually the most valuable are the ones that are, let's say, an interface, right? So if an interface patent issues, you know the other guy infringed because he interoperates with you. And so I think that's one of the reasons why some of these functionality, do this function on the internet, is really attractive, is because you can tell when somebody's infringing. So I think some of the limitations of the patent system for software really has to do with the embeddedness of a lot of the what Mitch Kapor and two other co-authors of mine called the industrial compilations of applied know-how, which is where a lot of the value in software lies. And for that, trade secrecy is on average the best way to protect it.
So for those who didn't fully catch all that, Pam, that's an interesting statement I had not thought about. The software patents that may reflect the most invention and novel activity are ones that are hardest to actually sue for infringement on because you won't know that it's being infringed.
Yes, except against an open source developer who actually then reveals the source code that embeds the technology. So oddly enough, open source developers are more likely to be open to software patent lawsuits than proprietary companies that only give object code out to customers.
And that would seem to be an area that insurance might have a little more, large companies use open source, do they use insurance against those type of lawsuits?
So we do in fact insure one of the larger open source software providers, so yeah.
Yes, that would seem like it would be an area where that would make sense. All right, more questions? We have, yeah.
Yes, I was interested in hearing the panel's comments about how joint defense agreements help hinder against the patent trolls.
I'm sorry.
So I'll repeat the questions, everyone hears it. So the question is, when you get into litigating against MPEs, patent trolls, to what extent are joint defense agreements helpful? And particularly, Jason, can they help startup companies? You answered a little bit before by suggesting they're strategic about how they do the lawsuits so they don't sue everyone at once. But to the extent they do sue multiple people at the same time, how much do joint defense agreements help?
You know, it can go either way. If you have really great alignment between companies, it can work, but usually that doesn't happen and somebody blinks first. It's sort of an expanded version of the prisoner's dilemma, right? You're all in jail, somebody's going to get out first, and so they do, and the rest of the dominoes fall.
You know, one idea you might want to consider, though, is pooling resources, pooling money if it's too expensive for any target individually, to put the patent into a re-exam or inter-parties review, some sort of validity challenge at the patent office, and sharing expenses that way.
But if it stands up.
Right.
If it stands up, you're in trouble.
You're in trouble.
Or maybe you get it.
Full disclosure.
Right.
A quick add on the joint defense thing. There's a big asymmetry between big companies and startups in a joint defense context. $1 million to Google is very different than $1 million to a startup, or $5 million is very different to Google than $5 million to a startup. And so in those situations where you have asymmetry, especially where there's multiple big companies and one small company, you often get into a difficult situation, especially if the troll's going after the small company first, and then by inference, the customers of the small company. So you get into these tangled situations that on the front end seem like they should be easy to work out, but then when the lawyers on the side are yelling at each other about the joint defense, and the dollars are starting to escalate, the startups often get into that place.
Yeah, the biggest one we see, by the way, is you got 3 startups. One is about to go raise financing, 2 aren't. One does not want to have, I'm in the middle of a patent litigation on their fundraising deck. How much does it cost to get out? 75 grand. It's a business decision. Sell it the other 2.
So Suzanne, here's a question related to that. One would think that if you see what's going to happen, the larger companies would actually be willing to get involved earlier on invalidity in cases, even if they aren't being sued. Do you see that happening at all, where literally you're aware of a MPE activity that is ultimately coming to your neighborhood and companies get involved sooner to do something about it, or generally they wait till they're being sued? Because there's so much of it happening.
Depends what you mean about getting involved. It might not be possible to intervene in the case and actually take over the case. Where company might do that, and Google has done that, is if it's really one of our products. You know, if maps and websites are being sued for having maps on their website, Google might want to defend that technology rather than have someone else do it and intervene. But those are tricky decisions. Putting a patent into the patent office for reconsideration is another way we have sometimes done that, although again, those are, there are reasons. It's difficult to do that if you haven't even been challenged. You might not want to. So it doesn't always save the day. Not a great answer, but.
Danny?
Does Google file software patents?
Oh, well, yeah, I'm not sure. Yeah. So we have a lot, yes.
I know.
And again, how do you define, so I think Google has a broad range of patents on software.
So I have a million questions for you guys, but I'll just, to pick one. So Professor Samuelson's study was a very interesting read, and I thought there were a lot of really interesting results from it. And it did definitely differentiate between, you know, VC-backed and non-VC-backed and some other things. But one place it didn't really differentiate was the types of software developments that are, let's say, mobile apps, where it's very quick to develop, very social marketing driven, quick in, quick out kind of things versus something where it takes years and lots of money to really develop the software. The software is really very intertwined in the hardware, all kinds of things of that sort. And I'm curious, Jason and Suzanne, the people on the panel, how you think that affects the debate and how you advise product teams, clients, et cetera, differently in those different contexts.
So I don't. But we're biased. We don't invest in what I call big bang development, where you spend 2 years making something and show up and say, here's a product. We're investing in things that are much more rapidly progressing. So I may have a biased viewpoint. By the way, let me take one tangent and then try to directly answer your question. The difference, Pam's VC versus non-VC difference could be easily also explained that before you're VC funded, you have no money to file patents. It's just luck. It's got nothing to do with whether you're VC backed. You just have more money, and it's something you have to do because of the situation. I don't think that patents in venture world for software companies have any effect on innovation or competitiveness. I just don't see it. I've been doing it for 15 years. We've never taken an offensive patent situation. You out-execute. It's what I said about the Google model. They were not first. They just did it better.
And next question.
As we continue these discussions, I think there's an underlying bias among some commentators and even some judges on whether software engineering is a real discipline, if software engineering is real. Personally, I was a software engineer before I was an attorney. I work with software engineers that I think are amazingly smart and whose innovation deserves protection just as much as the chemical engineers. But I just wanted to get the panel's comments and see how much do you think that maybe that is affecting things in the debate, or maybe is an unseen part of this debate.
Well, this gets back to the thing we talked about before. There's some great software research and invention and innovative activity happening, and there's a lot of functional patents that purport to be software patents that don't reflect that. To what extent is that second category just swamping, eclipsing, and giving a bad name to the first?
So let me say a couple of things about that. One is that, there are really important inventions in software, really brilliant things, and if companies want to protect that with patents, we're not suggesting abolishing software patents. I think what you said is interesting when you read some of the case law. And there's this stream in the case law that I think's created a lot of problems, which is that programming is a routine activity once I've named the function. And what that has led to is the kinds of patents that we're talking about is a problem. The patent that claims the function at a high level really has not much description in it. I'm thinking about one patent that we've been charged with, which is about downloading documents from the cloud. There's literally one paragraph. It was written by a patent lawyer, the whole patent. He's the inventor. Download the documents from the cloud. It doesn't talk about anything involved there. And what these kinds, that's a problem with 112 case law. In the 112 case law, that has really fed this problem of these overbroad patents, which allow people to get patents doing no work. Just writing the patent is their work. And then tax other companies and startups that are really trying to create something and do the hard part. And
so I want to say I'm married to a software engineer, and he's one of the most creative people I ever knew in my whole life. And I've had the great fortune to work for 30 years with people in software companies and also in the academic community of software. And I think they're the most brilliant people on the face of the earth, okay? I completely think they're just brilliant. I'm so glad they're doing what they're doing. I just don't think the patent system and the software, even among creative people, is a really good match. And so that's where I'm kind of coming from. I just think there's a fundamental mismatch. And when I talk to a lot of people who are very creative people in the software industry, Mitch Kapor was one of my co-authors on a paper about legal protection of computer programs. He thinks software patents are a terrible idea. But I would say he's one of the most creative people in that field from way back. So I think that's the thing. If I have to say, are they creative? Yeah. Does that mean necessarily that that they should be that they should be getting patents? I have a colleague who says, oh, you know, there's now degrees in financial engineering, and therefore all financial innovation should be patented. And I said, my husband's written a book called Document Engineering. Does that mean that all people who design documents are now eligible for patents? I think the question is whether or not the patent system is doing something, and I don't think it's all about reputation or validation, and oh, if you say that software is not patentable, that means that you're demeaning somehow the profession. I don't feel that at all.
Well, the question is, does patents spur people like your husband to innovate, or does he just
And
do
the
what he do?
answer is no.
There you go. So it's not demeaning or saying it's less. It's what do we need to incentivize this country to innovate?
Although I think, I want to come back to Suzanne's point and put Paul Ohm on the spot, because there is language in these cases that says once you've identified the function, everything that happens after that is like a trivial thing. My question is, could someone who's actually a software engineer have written that or believed that, or is that the product of lawyers who just fundamentally didn't understand the enterprise?
Softball.
So my rule is, if I'm in a room of lawyers, I have to pretend to be the most knowledgeable engineer. And if I'm in a room of engineers, I have to pretend to be the most knowledgeable lawyer. And I'm not sure what the makeup of the room is. So it's a little hard for me to answer the question. But I think, suffice to say, I think consistent with what both of the earlier two just said, there is a ton of creativity and innovation and the kind of thought that you associate with tactile, physical things that may not be getting credit in some of the analyses that we're seeing, right? And so I totally agree that if the way we're going to get rid of software patents is to kind of denigrate a profession, well, let's find a better way to do it, and let's not undersell kind of the creativity. But I think there are other strains in these cases that go at it different ways that say, in fact, copyright and trade secrecy and all these other things are wonderful incentives, and more to Jason's point, if we can find ways to turn up that knob and increase those incentives, all for the better. But patent is having all sorts of disruptive things and probably not doing the work it's supposed to be doing. Did I get at your question?
I mean, I was asking a slightly different one, which was on Suzanne's point, which is that the lack of appreciation for what happens other than identifying the function is part of what's created the situation we're in. Had the Federal Circuit been more knowledgeable about, the intricacies of software, might they have been a little bit more careful than to sort of give a green light?
Perhaps. Whenever I'm asked a question about are judges to blame for their lack of technical know-how, my answer is always the litigants are to blame, right? So ultimately, at some point, I fully believe that some litigant did a lousy job spelling out for the judges exactly what happens in the computer engineering process. And I think you're right now that you're having me think about it. There are clearly some misunderstandings in some of these opinions about what happens, but I put that all on the litigator's shoulders, not on the judges. Tell the judges the way it works, and they'll do a nice job sorting it out.
All right, we have time for one or maybe two more questions.
Hi, Pam. I would say that trade secrets are no good because having been in software development for 22 years before I became a patent lawyer, I never had a job for more than 3 years. So therefore, the secrets move. And, raise your hand if you've been in software for more than 2 or 3 years. The migration between firms, it makes the trade secrets go with the brain, and it doesn't work, personal opinion. So, but back to copyright, it's so narrow. 1 year later, the lady with the rose got wrinkles, so the copyright from the year-old photo doesn't work. So that's no good. And so you're left with patents, which is a constitutional right supposedly to spur innovation. And I think anyone with software knows whether you build a chair or software, you're a highly creative person. You deserve protection under the Constitution. And so I don't think there's a debate there. The question is, our legal justice system, I think, and my question to you is a full generation behind the technology. So we have a government that is so fraught and shut down. By the way, the patent office is going to shut down in 30 days except for filing your date. So all your software patents will be on hold for infinite, instead of 5 years, maybe 15 years. So the question is, how do we incentivize government to realize that we need to protect and improve perhaps every back to the old days where we don't have a central court with 3 judges deciding the fate after 50% rejection, you know, at the district court level, which is ridiculous. So if you don't have the Google pocketbook, you can't possibly fight as an entrepreneur to protect your rights. So maybe we need a incentivization at the government level to redesign our court system to make the innovation in software really work. I would throw that out, especially to you guys who have such brilliant people in your employ, Google, for example.
So our next panel is going to talk a bit about the administrative and judicial system, but I think it's fair to give folks here a shot. If you were to redesign the judicial and administrative system with software in mind, how would you change things? Any thoughts on that?
Well, I think one thing that would help is to have people who have some training in software actually making some of the judgments. One of the reasons I think we have bad problems with software patents now is that for many years, if you had a degree in computer science, you couldn't become a patent examiner, and yet they were issuing software patents. And so expertise is pretty important. I think one of the things that the district courts have done in recent years is really try to focus on building expertise in some of the judges so that at the trial court level things are done in a better way. So that's been a good thing. I know that the Patent Office has been thinking about also a small claims process, and that might be a way to deal with some of the issues also. But I think that part of what we are learning about software patents is that isn't one problem. It's a set of problems. And to go back to Suzanne's point, trying to really understand what are the cluster of problems and that are at the core of why we can't do this really well now, and then trying to sort of address each of them would probably be the best strategy. And I'll look forward to hearing what the next panel has to say to fill in some of the details.
Well, let me give everyone on this panel a chance to fill in some details, because we'll have two panels on, like I said, judicial and administrative remedies and self-help and legislative ones. Suzanne, you talked about these root causes and things, and you mentioned the disclosure problem, section 112. What are some of the things that, as looking at these next two panels, you think are important to talk about and think about as trying to, if you will, re-engineer the system?
I can talk for an hour on that. But okay, so quickly, in the Patent Office, I have come to really dislike the idea of rational ignorance in the Patent Office.
This is Mark Lemley's article. He's talked about it here before, just so people know. It's basically, don't worry about whether you grant good patents in the front end or not, because if they matter, the courts will handle them in the back end.
Right. And when that article came out in the early 90s, and his point being very few patents are litigated, it might have seemed like an okay argument. But what I think we've seen, though, is that an improvidently granted patent, a patent that the Patent Office spends 18 hours on, that the application fees are a few $1,000s, has the ability to wreak hundreds and hundreds of millions of dollars of havoc. And that's not rational. And so we need to put a lot more resources up front because of the power of the patent. Some of that power comes from the problems of civil litigation in the United States, and that it's so expensive and so drawn out, and that's really where the power of the patent's coming from rather than the technology. And so we need to have a much more streamlined dispute resolution process, and I think having better programs than we currently have for challenging bad quality patents in the Patent Office. Google in particular likes expanding the covered business method system that's already there, but there's other ways to do it. It is another really important one. The other theory that I think we just haven't integrated enough into the court system is a John Duffy argument and it's come up and referred to here a couple times. Patents should be granted when we wouldn't have gotten the invention but for the fact that the patent was the inducement for doing this. Is the patent, and if that's not the case, we shouldn't be giving patents because we're just taxing innovation. And that idea has to get much, much deeper into our court system, in our whole system, to have a more rational patent system.
3 quick hits to start taking jurisdiction seriously. Just because I'm on the internet doesn't mean you can sue me in Texas. 2, winner gets attorney's fees. I think would have a huge change. And third, much like we have in criminal versus civil, I think we should have a different burden of proof for proving damages if you're an NPE or troll, akin to criminal murder, which is beyond a reasonable doubt and preponderance evidence in the civil cases.
Pat?
So to address your question earlier, this woman who has a software background, I think the lower in the stack you go, the more likely you are to get a real patent from a software design perspective, because you're going to be at the interface level. The higher you go as far as the apps, I think those are going to get weeded out over time. Unfortunately, they cause a lot of damage. My remedy as an entrepreneur is create a patent court, much like the Germans have.
A trial court. So not a court of appeals that's specialist, but a patent trial court.
Correct.
Yep.
As the German system has, they have 3 lawyers. Usually one has a technical background, and they're specialists at patent litigation. And Germany has now become the best venue if you have a real patent. If you don't have a real patent, you probably would do better in the States.
A number of people said this, the modernization law that created the Federal Circuit got it exactly wrong. You should have specialized trial courts in general, the Court of Appeals, not the other way around.
In retrospect, that would have been a better idea.
Hindsight's 2020.
Yeah. So, RPX recently ran a patent reform working session, which is interesting, getting people's perspective. I think you can group all the problems into 4 buckets. There's a quality problem, a notice problem, a valuation litigation problem, an information asymmetry problem. You want my personal take? If I had to choose 2, I would say patent quality. I mean, the fact that I think the GAO just estimated that 70% of examiners have been at the USPTO fewer than 5 years. That's a problem, and if you just increase the quality, there are good software patents out there. We don't see a lot of them at RPX. Honestly, most of the stuff we see is nuisance grade ridiculousness. It should never have been issued in the first place. Clean those up, you're most of the way. The other side is litigation. RPX wouldn't have a business if litigation was efficient, really, because that's 2 sides trying to get to the value of it, and this is where we try to step in. The most interesting proposals that I heard from the industry was more taking the valuation part of the case and moving it up, higher pleading standards, moving damages, before claim construction, because most of the time, once you understand how much is at stake, both sides would walk away. And then if possible, moving claim construction up in front too, pushing all that stuff.
Thank you guys. It was a great discussion. Let's take a little time for a break.